Hello everyone. Today we will solve a few most important MCQs on Writs. Okay. So if you have analyzed previous year question paper of All India Bar examination, so you have probably noticed that maximum 2 to 3 questions are asked covering the topic Writs. Okay. So this Writ portion. Okay. This Writ portion is very important for our exam preparation. Okay. So as you will know that in Indian Constitution total question will be asked, that is 10 questions. Okay, that means 10 total 10 marks का question पूछा जाएगा, isn't it? And out of that minimum 3 questions. Okay, 3 questions will be asked from reads. So you can imagine the weightage of this topic, that is reads. Okay, so reads. Okay, so without any further delay, let's start today's session. Okay, so today's first question देखिए क्या है, which of the following writ is considered as the bulwark of professional freedom? Okay, what is bulwark? Bulwark means a defensive wall, a defensive wall. Okay, so options are mandamus, habeas corpus, certiorari and quo warranto. That means question क्या बोला देखिए, which of the following writs is considered as the bulwark of the personal freedom? So in this case the correct option would be habeas corpus. Okay, habeas corpus means to have the body. Okay, that means if any person is illegally detained or unlawfully detained, then in that case we can file the writ of habeas corpus in the directly to the Supreme Court or the High Court. So under Article 32 we can file the writ petition to the Supreme Court. Okay, and Article 226. Okay, under Article 226 we can file the writ petition directly to the High Court. Okay, so in this case the correct option would be option B. Okay, so now let's the explanation for better understanding. देखिए explanation में क्या लिखे देखिए, the explanation is the writ of habeas corpus is issued to prevent the illegal detention of the person or and to secure his or her release in such case. Therefore, habeas corpus is protects the personal freedom of the person. That means अगर कोई person को illegally और unlawfully detain किया गया है, then in that case क्या होता है, we can file the writ petition directly to the Supreme Court or High Court. As I already mentioned, the Supreme Court under which article? Under Article 32, and High Court under Article 226. Okay, 226. That means under Article 226 we can file the writ petition directly to the High Court, and under Article 32 we can directly file the writ petition to the Supreme Court. Okay, so in this case क्या होगा, in this case option B would be the correct answer. So now move to next question. Okay, next question is, which of the following articles of the Constitution relates to the issuance of writs? Okay, that means इनमें से कौन सा आर्टिकल इशू करता है, ठीक है. So options are Article 32, Article 139, both A and B, and none of the above. Okay, so in this case the correct option would be option C. That means Article 32 and Article 139 both. Then that means under Article 32 we can directly file the writ petition to whom? To the Supreme Court. To the Supreme Court. Okay, for violation of any fundamental right, isn't it? Fundamental rights. But under Article 139, if there is any violation of any rights other than fundamental right, that means other than fundamental rights, that means अगर fundamental rights का violation होता है, देखिए डिफेंस देखिए, अगर इफ देयर इज एनी वायलेशन ऑफ फंडामेंटल राइट देन वी कैन फाइल द रिट पिटिशन डायरेक्टली टू द सुप्रीम कोर्ट अंडर आर्टिकल 32. ओके, एंड अंडर आर्टिकल 139 कब हम रिट पिटिशन कर सकते हैं? वी कैन फाइल द रिट पिटिशन अंडर आर्टिकल 139 इफ देयर इज एनी वायलेशन ऑफ राइट्स अदर देन द फंडामेंटल राइट्स. अगर फंडामेंटल राइट्स के अलावा अगर कोई भी राइट्स, कोई भी लीगल राइट्स वायलेशन हुआ है, इन्फ्रिंजमेंट हुआ है, देन in that case only we can file the writ petition under article 139. So this is very important question. Okay, so in this case क्या होगा? In this case option C would be the correct answer. Okay, so now read explanation for better understanding. देखिए, article 32 gives the power to the power to issue the writs to the supreme court. Okay, and article 139 allows the parliament. Okay, देखिए, parliament to make laws, okay, for the issuance of writs. Hence the correct answer is both A and B. That means देखिए, आर्टिकल 32 किसको पावर देता है? आर्टिकल 32 पावर देता है सुप्रीम कोर्ट को, लेकिन आर्टिकल आर्टिकल 139 किसको पावर देता है? आर्टिकल 139 पावर देता है पार्लियामेंट को, ठीक है, टू मेक लॉज फॉर द इशुएंस ऑफ रिट. अगर आर्टिकल 32 इज ऑल अबाउट सुप्रीम कोर्ट एंड आर्टिकल 39 is all about the parliament. Parliament has the power to make laws if there is any violation of any rights other than the fundamental right. Okay, fundamental, अगर fundamental rights है तो जाएगा article 32 में, and then other than fundamental right होगा, then it will come under article 139. Okay, so in this case the correct option would be our option C, that means both A and B. That means option C would be the correct answer. So now moving to next question. Next question देखिए. Next question is writ of mandamus relates to which of the following? Options are performance of legal duty by any public authority, quashing of an order passed without jurisdiction, inquiring into the authority by which a public office is being held, and preventing an inferior court from acting without jurisdiction. Okay, without jurisdiction. So in this case the correct option would be option A. That means option A would be the correct answer. That means देखिए, writ of mandamus refers to which? The writ of mandamus means we command. देखिए, mandamus का मीनिंग क्या है? मीन्स we command. That means in case the court issues the writ of mandamus to the public officer, to the public officer, okay, to the public officials to perform their legal duty, okay, which they are bound to perform, which they are bound to perform. ओके, दैट मीन्स अगर कोई भी एक पब्लिक अथॉरिटी है जो कोई भी अपना काम ठीक से नहीं कर रहा है और which he has failed to perform, okay, then in that case the court may issue the writ of mandamus to that public authority to perform his legal duty. Okay, so in this case option A would be the correct answer. Now read explanation for better understanding. देखिए, the writ of mandamus relates to the performance of the legal duty by a public authority. That means if there is any mistake or if there is any failure on the part of the public authority to perform his duty, in that case the court may issue the writ of mandamus to perform his duty properly. Okay, so in this case option A would be the correct answer. Okay, now move to next question. नेक्स्ट क्वेश्चन देखिए, which of the following articles of the constitution allows issuance of writs for the enforcing right other than the fundamental right? As I already discussed earlier that article 32 is all about violation or infringement of fundamental right. article 226 में भी same है, if there is any violation of fundamental rights, that means कहाँ पर जाता है? ये जाता है हाई कोर्ट के अंदर जाता है, रिट पिटिशन फाइल किया जाता है, एंड अंडर आर्टिकल 32 कहाँ पर to the directly Supreme Court. Okay, but under Article 139, so अंडर आर्टिकल 39 में क्या होता है, पार्लियामेंट को पावर दिया गया है टू मेक लॉज. ओके, इफ देयर इज एनी वायलेशन of legal rights other than the fundamental right. So in this case the correct answer would be option C. That means option C would be the correct answer. Okay, now let's read explanation for better understanding. देखिए आर्टिकल 139 ओके कॉन्स्टिट्यूशन ऑफ इंडिया अलाउस इंडियन पार्लियामेंट. देखिए आर्टिकल 139 किसको पावर देता है, इंडियन पार्लियामेंट को, टू मेक लॉज फॉर कन्फरिंग ऑन द सुप्रीम कोर्ट द पावर टू इशू रिट्स फॉर द एनफोर्समेंट ऑफ राइट्स अदर देन द फंडामेंटल राइट. दैट मीन्स इंडियन पार्लियामेंट को पावर दिया गया है to make laws if there is any violation of any legal rights other than the fundamental right. So in this case क्या होगा, in this case option C would be the correct answer. So now move to next question. Next question देखिए, how many kinds of writs have been recognized under the Indian Constitution? Options are 4, 5, 6 and 7. Okay, so in this case the correct option will be option B. That means under Indian Constitution there are total 5 kinds of writs which have been recognized under the Indian Constitution. Okay, that means there are total 5 kinds of writs which have been recognized under Indian Constitution. These are, first one is habeas corpus. Habeas corpus. Second one is mandamus. Mandamus. Third one is prohibition. Prohibition. Fourth one is certiorari, and the fifth one is quo warranto. Quo or warranto. Okay, so in this case the correct option will be option B. For better understanding, the Indian Constitution recognizes 5 kinds of writs, namely habeas corpus, mandamus, certiorari, quo warranto and prohibition. That means total writs have been mentioned under Indian Constitution. So now move to next question. Suppose X is aggrieved by an order passed by the District Court, New Delhi, without having jurisdiction. Which of the following writs is the proper remedy available to X? Options are mandamus, prohibition, quo warranto and certiorari. So in this case the correct answer would be option D, that means certiorari. Certiorari. Okay, so in this case option D would be the correct answer. So now let's read explanation for better understanding. Okay, X can seek a writ of certiorari to get the consent order quashed by the High Court or the Supreme Court. That means if the court pass or give any judgment without having proper jurisdiction, then in that case the writ of certiorari can be issued to the High Court or the Supreme Court to quash that order or judgment. Okay, so in this case option D would be the correct answer. Okay, so now move to next question. Next question is, A. Being illegally detained by the police authorities. Okay, which of the following writs can be wife can seek from the court to secure his release? Options are habeas corpus, mandamus, prohibition and certiorari. So in this case the correct option would be A, that means habeas corpus. That means if there is illegally, if any person is illegally detained or if any person is unlawfully detained, unlawfully detained, then in that case the writ of habeas corpus can be issued to release that person, and that writ can be filed to either to the High Court or to the Supreme Court. Okay, तो अगर हाई कोर्ट होगा अंडर विच आर्टिकल, अंडर आर्टिकल 226, एंड अंडर अगर सुप्रीम कोर्ट होगा तो अंडर विच आर्टिकल, अंडर आर्टिकल 32. Okay, so in this case option A would be the correct answer. So now let's read expression for better understanding. देखिए, as wife can seek a writ of habeas corpus to secure as release. Okay, so in this case, option A would be the correct answer. So now move to next question. Next question is, it is general rule that a person cannot seek issuance of writ in the event that an alternative remedy is available. So the options are true, false, true, subject to certain exceptions, depends on the discretion of the court. So in this case, the correct option would be C. That means true. That means it is general rule that a person cannot seek issuance of writ in the event that an alternative remedy, agar if there is any infringement of right and there is an alternative remedy is also available, then in that case a writ petition cannot be filed directly to the High Court or the Supreme Court, but subject to certain condition. ठीक है, to subject to certain conditions. So writ explanation for better understanding. The rule that writ cannot be issued in case of existence of an alternate remedy. अगर if there is any infringement of right and there is an alternative remedy other than filing a petition, then in that case a writ cannot be issued directly to the High Court or the Supreme Court. Okay, but it is also subject to certain exceptions, such as violation of principles of natural justice. That means if there is any violation of principle of natural justice, then in that case the writ can be filed directly to the High Court under Article 226 or under Supreme Court under Article 32. Okay, so in this case option C would be the correct answer. So now move to next question. Next question is, writ can be sought for the enforcement of, options are fundamental right, contractual right, statutory rights, none of the above. So in this case the correct option would be fundamental right. That means option A would be the correct answer. That means writs can be issued, writs can be sought for the enforcement of only fundamental right. That means to next question, and this is the so now move to next question, and this is the last question. Okay, a writ of certiorari can be issued to prevent an inferior court from proceeding further with a case due to lack of jurisdiction. Okay, so the options are true, false, cannot say, false, writ of mandamus can be issued. So in this case, the correct option would be option B, that means false. Writ explanation for better understanding. The given statement is false as a writ of prohibition. The writ of prohibition is issued to prevent an inferior court from proceeding further with a case due to lack of jurisdiction. But certiorari is issued to quash an order passed without jurisdiction. That means अगर कोई proceeding चल रहा है before any inferior court without having jurisdiction, then in that case writ of prohibition can be filed. But if but if a lower court pass but if a lower court passes any order without its jurisdiction, then in that case the writ of certiorari can be issued to that court to quash its order. Okay, so this is for all today. If you liked this lecture, please like this video and please subscribe this channel. Okay, see you in the next video.